What's going on in the big old town of LaSalle today, people? I'm going to bring you the latest and greatest. And Carus Chemical got some violations from the EPA. But you know what? Carus is going to go ahead and fight them violations just like any other chemical company will. But I'm going to show you some proof. I'm going to show you the evidence. They knew what they were doing. They knew that that cardboard was not supposed to be used in that factory. It is a combustible material, and we'll get to that. This is the Mahoney versus Carus Chemical Company case, 1986.
Mahoney versus Carus Chemical Company, Inc., 102 NJ 564, 1986, 510A.2D4. Thomas P. Mahoney and Barbara Mahoney, his wife, plaintiffs appellants, the Carus Chemical Company Incorporated, and Carus Corporation Carus Chemical Co. Division, Hungerford and Terry Incorporated, and Inversand Company, jointly, severally, and in the alternative, defendants respondents. The Supreme Court of New Jersey. Argued February 19, 1985. Re-argued March 3, 1986. Decided May 21, 1986. Asterisk 566 William J. Cook argued the cause for appellants, Brown, Connery, Culp, Will, Purnell and Green, attorneys. F. Herbert Owens, 3, argued the cause for respondents Carus Chemical Company Incorporated and Carus Corporation Carus Chemical Company. Division, Montano, Summers, Mullen, Manuel and Owens, attorneys. John P. Morris argued the cause for respondents Hungerford and Terry Incorporated and Inversand Company, Horovitz, Perlow, Morris and Baker, attorneys. Michael A. Paroli on the brief. Barry T. Parker argued the...
I apologize. This is a bunch of mumbo jumbo in the beginning here, but it will get better. I will skip around and get to the good parts. I just want you to know that this is a real document. This is a real court case. These are real Carus Chemical quotes.
Paramicus Curiae New Jersey State Firemen's Association, Parker, McKay and Criscolo, attorneys. The opinion of the court was delivered by Stein, J. In this appeal we consider whether the immunity afforded by the fireman's rule insulates from liability a defendant whose willful and wanton misconduct is the proximate cause of the fire that compelled the fireman's presence at the fire scene and caused him to sustain injury. A related issue concerns the asterisk 567 application of the fireman's rule to the manufacturer of a defective product that is alleged to have caused the fire in which the firefighter was injured. Plaintiff Thomas P. Mahoney was a volunteer firefighter with the Highland Chemical Engine Company of Pittman, New Jersey. On June 19, 1978, duty called him to the scene of a fire at the Inversand Company chemical plant in Sewell, New Jersey. Based on his prior knowledge of the Inversand business, he knew the fire to be chemical in nature. He concedes that he understood the severe risk of entering a building engulfed by a chemical fire, including the risk of the structure falling. While straddling the threshold of the burning building, a structural wall collapsed on him, trapping him inside the building and causing his injuries. He sued Inversand, Inversand's parent, Hungerford and Terry Incorporated, and Carus Chemical Company Incorporated, Carus, the Illinois corporation that supplied Inversand with the highly combustible substance that allegedly caused the fire. 1. Plaintiff was prepared to prove at trial that as a result of the accident at the firefighting scene, he was critically injured, suffering massive burns on his body, crushing injuries to his right upper extremities, fractures of the right arm and pelvis, and multiple abrasions and contusions. The trial court, relying on the fireman's rule, Croft vs. Geller, 31 NJ, 270, 1960, granted summary judgment in favor of all defendants. The appellate division affirmed. We granted plaintiff's petition for certification.
Now, what this means up here, basically, this is a fireman. He's a volunteer fireman. He was called to the scene of a fire on June 19th, 1978. The issue was that this was they had Carus Chemical product in there, and we'll go on with the rest of it. They get in detail of what's going on with this case.
86 NJ 314, 1984. Our principal focus is on his claim against Carus. The gravamen of that claim, as disclosed by the complaint and documents obtained during discovery, is that the fire at the Inversand warehouse spontaneously ignited in one of a shipment asterisk 568 of fiber paper drums containing potassium permanganate powder, brand name Carox, manufactured by Carus and received by Inversand approximately 2 hours before the fire. That Carus, based on a series of similar fires, knew that shipment or storage of Carox in fiber paper drums created a significant danger of spontaneous ignition, that the risk of spontaneous ignition of Carox in fiber paper drums was so substantial that Carus, in internal memoranda and in a communication to customers a month before the Inversand fire, had announced its decision to replace the fiber paper drums with metal containers, that the shipment to Inversand included 86 metal drums of Carox, none of which burned, and 100 fiber paper drums, virtually all of which burned, and that Carus had continued to ship Carox in fiber paper drums in order to exhaust its supply of such drums before making the switch to metal containers. Documents submitted by plaintiff in opposition to defendant's summary judgment motions set forth a detailed factual background in support of the allegations in the complaint. According to plaintiff, Carus is the sole United States manufacturer of potassium permanganate, a chemical used both as an oxidizing agent and as a disinfectant. Plaintiff.
Now this is a fact. They are even bigger than that now. They're not only in the United States; they are worldwide, people. You got to remember, this was back in the day.
Contends that potassium permanganate is a dangerous compound because it readily causes fire when placed in contact with combustible materials. Plaintiff's documents included excerpts from scientific manuals that plainly identify the fire hazard inherent in potassium permanganate, describing it as a powerful oxidizing material that reacts violently with finely divided, easily oxidizable substances, and increases flammability of combustible materials.
Now let me ask you something, people. This is where our city comes into play. A powerful oxidizer that reacts easily. It's increased flammability of combustible materials, people. The OSHA violation that they received was they had the product and they were using combustible materials around that product. That would be cardboard. We'll get further into that here in a second.
Potassium permanganate's hazardous properties were confirmed by plaintiff's consulting engineer in a report that was part of the trial court record. According to plaintiff, Carus did not ship potassium permanganate in fiber paper drums until December 1975. Carus allegedly considered using fiber drums in 1965, but rejected the idea because it recognized that here is a greater potential fire hazard when fiber is used in place of metal as a container. It is uncontroverted, however, that in late 1975 Carus began using fiber paper drums to ship potassium permanganate. Plaintiff alleges that this was an economic decision predicated on Carus's estimate that it could save $35,000 annually by using the less expensive fiber paper drums. Plaintiff also alleges that Carus recognized the increased hazard to its own premises when it acknowledged that it is most likely that we would have to install a sprinkler system in the Carus warehouse if we switch to fiber containers. It is also uncontroverted that the bottom and sides of the fiber drums used for shipping potassium permanganate were combustible, and in its answers to interrogatories, Carus conceded that potassium permanganate increases the flammability of combustible materials and should be kept away from certain combustible materials. An internal Carus memorandum entitled Reported Fires Involving Carus in Fiber Drums was also part of the trial court record. This document revealed that beginning in February 1976, 2 months after Carus initiated the shipment of potassium permanganate in fiber drums, a series of spontaneous, unexplained fires occurred at various Carus storage locations, causing partial or total destruction of the fiber drums as well as considerable damage to surrounding property. Pertinent portions of this document reveal the following information. Asterisk 570 reported fires involving Carus are, in fiber drums, probable geographic specific place, cause, date, location. The fire occurred of ignition damage 25-26 February. 50 miles north trailer with 30 spontaneous, total loss of 76 of salt estate. Drums KMNO 4 reaction trailer in Marie, Canada, 3,000 kilograms between cargo and KMNO 4 and other damage isopropyl ethyl thionocarbamate. Physical damage to fiber drum apparently was involved. Also May 23rd, 76 Huntington railroad freight, no clues, partial loss BC car width of cargo 18,933 pounds. Damage to car KMNO 4 February 8th, 78 Boonville railroad freight damage, total loss of AR car with 450 containers. Freight cars fiber drums friction with cargo KMNO 4 60,220 pounds. March 31st. Doraville, Georgia trailer 250 kilograms, no clues, total loss of 78 Ashland drums trailer and cargo April 10th. Sparrows warehouse possible $11,000 worth 78 point. MD interaction of physical Bethlehem with damage plus steel. Biourea 60 hours worth of labor June 19th Sewell, New Jersey warehouse, no clues, loss of 78. Inversand warehouse August 15th. 3 miles north truck containing no clues damage to 78 of New Bern. 10 drums truck NC 1,000 kilograms. Cleanup KMNO 4 costs total $3,814. Plaintiff alleges that after the 7th fire in August 1978, Carus discontinued the use of fiber drums and that there have been no reported incidents of such fires since then. Asterisk 571 Carus concedes that it decided to discontinue the use of fiber drums after a fire at Bethlehem Steel Company on April 10, 1978. An internal Carus marketing memorandum dated April 17, 1978, confirms this decision. As a result of a series of fires involving Carus in fiber drums, we have decided to eliminate the use of fiber drums and revert to all metal drums. On May 5, 1978, Carus communicated this decision to its customers in writing, informing them that this change would result in a cost increase of 1.5 cents per pound to be passed on to them. Carus justified its decision as follows. Carus shipped 31,460 pounds of potassium permanganate to Inversand on June 13, 1978. Notwithstanding its announced change of policy regarding the use of fiber drums, approximately 22,000 pounds were shipped in 100 fiber drums. The balance was shipped in 86 metal drums. The shipment arrived at the Inversand warehouse at about 11:30 a.m. p.m. on June 19, 1978. At approximately 12:45 p.m., an Inversand employee noticed pink smoke coming out of a Carus fiber drum that was stored inside the warehouse. Fire broke out and spread to the other fiber drums. 7 volunteer fire companies and 5 rescue squads responded to the alarm. The warehouse was substantially destroyed. Volunteer fireman Mahoney was standing at the entrance to the building when a structural wall collapsed on him, causing severe and permanent personal injuries. In establishing the fireman's rule in New Jersey, this court expressly considered the relationship between the conduct responsible for causing a fire and the fireman's right to recover for injuries sustained in fighting the fire.
Now, basically what this is going to go into from now on, they're going to go back and forth with laws. Each attorney is going to rebut. And basically they're saying that the negligence of Carus Chemical knowingly using these cardboard containers and knowing that what they do, they are negligent and should be held responsible. I'm not sure how much more I have to prove throughout this process, but this is getting to be very interesting. OSHA violations. I will let you know they're going to say they're going to fight it since I exposed it, which they are, and that's going to take up to a year. But they cannot deny the fact that they were violated and that this was on their permanent record, and I'm not sure